said I'm wasted.
I am wasted. Yeah, and then I came home and email. I didn't think I had.
You worked on email?
But I worked in email because I did a thing that I had missed.
Do you have a thought about gathering agenda items?
So what do you
It'd be better once today's over, but mostly, yeah. Oh, yeah. Yep, I was yesterday. They seem to both have a good day. They seem to have a good first day. Yeah. She.
Who is in the audience that should be at the table?
No.
Hello? Is this on now? No? Not yet? So we need to get that mic. That mic needs to come over here. We need to keep that doorway open.
Believe it or not, we rehearsed this. I asked them to rehearse it yesterday.
That's not, okay, I said that then.
Keep that doorway open.
Yes, I didn't feel like being here prior to that. That's
Why the overflow downstairs?
selfless, selfish.
I think you can just believe that it was enough.
There was then, but you know, what I'm not taking into account is that I have to do this every month. This now.
Yeah, we need to keep that high.
So I think we can discuss it.
Hey, Whitney, why don't you have the Olympian take one of those chairs? She's right there.
But the other thing is, we agreed no one. So, I don't know.
Do we have sound? We do?
We do
Yay, okay.
have sound? Sound? Check?
It's different, I guess. 'Cause no, but it didn't, it was fine.
No?
Hello? Hello?
Yes? No? Okay,
Hello?
thank you.
Hello?
All right, welcome everybody to the County Commissioner's ICE Arrest After Action Report. And first I want to welcome everybody that's here, and many of you came really early, so thank you. That was good planning. I'm going to go through kind of the sequence of events. There is an agenda, I think, on the back podium if you would like an agenda of how the meeting will flow. We'll start with introductions, and then I'm going to get into some other items here. I'm John Hutchings, the chair of the board, and this is
Gary Edwards.
he's the vice chair,
Time answer.
and
Ramiro Chavez, County Manager.
Elizabeth Petridge, Deputy Prosecuting Attorney.
John Tuna, Prosecuting Attorney.
Larry Jefferson, Public Defense. Patrick O'Connor, Public Defense.
Pam Hartman-Byers, Superior Court Administrator.
I'm Christine Schaller. I'm the presiding judge for Thurston County Superior Court.
Brett Buckley, Presiding Judge, Thurston County District Court.
Jennifer Brayton, District Court Administrator.
and on the back bench we have,
Whitney Pearsall, Administrative Assistant.
and,
Oh, really?
oh yeah, really.
Sarah Gensler, reporter with the Olympian.
Got it, thank you. Thanks for being here, Sarah. Pam, will you bring that microphone down here so you folks can share that? if need be, and don't be shy with picking up a microphone when you're speaking, okay? Thank you. I just want to explain this is an after-action report or briefing for the commissioners so we can find out all what the sequence of events, what happened, and kind of fill in some gaps. To be frank, all I know is what I read in the paper, and so there's no like insider information. This is a public, it's not a public meeting, but it's a meeting open to the public. And by that differentiation, I mean there's no opportunity for the public to address the Board of County Commissioners. If you want to address the Board of County Commissioners, next Tuesday, September 10th, at 2 in the afternoon is a BoCC meeting, and we always welcome public comment. But this is not the venue for that. This is for you to listen as we listen and take all this in, but no public comment at this point in time. And so by way of etiquette for this meeting, if you haven't already, please silence your phones. Please silence them so there's no disruption. And I ask also, respectfully, no outbursts of any kind, jeering, applause, loud sighing. It's kind of rude, but it's also kind of disrupts people's train of thought. And I definitely don't want to stifle any open dialogue at the table as well. So I greatly appreciate that. We're allotted 90 minutes maximum for this meeting. Could be shorter, but it won't be longer. I don't think it will be. So here we go. I'm going to turn now to County Manager Ramiro Chavez.
Thank you, Commissioners. Can you hear me okay back there? Okay, thank you. Also, follow up to Commissioner Hutchins. The public can submit written testimony anytime. So you can get into our website, and there is an opportunity for you to send an email, or if you like, you can submit via snail mail any comments that you would like to provide to the Commissioners and myself. That is always available. You don't have to wait until the 2 o'clock board meeting to provide your public testimony. Just a follow-up to that. So what I'm planning to do is just briefly outline what I understand the sequence of events, what occurred on June 20th, 2019. And I may not have all the details, but overall, this is just sets the stage for the conversation this afternoon. So my understanding of the issue on June 20th, 2019, there were what I believe 3 civilian-clothing ICE agents. They came just about 10:30 in the afternoon, in the morning, and they were using an unmarked vehicle. By reviewing some of the video footage, I realized that one of the ICE agents proceeded to access the security area in building number 2, which is Superior Court. And how I pinpoint that it was the ICE agent, because there was also a piece of a footage when the individual arrested was taken into the vehicle. So that was, for me, the time as to how I can connect the dots. So also, the agent was coming in and out of some of the courtrooms, and also looking at what I believe the calendar that is located on the main hallway in building number 2. So just about, I believe, 11:20 or so, and this is the time, it's just my understanding, it could be a little bit variances on the timing. He leaves Superior Court, building number 2, and then following up an individual who had court proceedings at that time. So the next step, what I realized, the 3 agents, ICE agents, was trying to subdue this individual, and they proceeded to arrest him. During the process, there was a little bit of a resistance by the individual, in which created a little bit of a commotion. And through the process, I believe that a security personnel responded to that commotion, as well as it was a corrections officer who was responding based on that radio call by one of the security officers, because at that point, nobody knew what was going on. It was just an apparent somebody was trying to, seduce an individual. So when a few individuals came and started observing, as well as some members of the public, then they realized that perhaps they were ICE agents because I believe they showed their IDs, and also some have some testimony, and some of the testimony, copies of those testimonies are available to you on that table, where perhaps they noticed they was carrying a firearm on their holster. And after that, they proceeded to put the individual into the unmarked vehicle. I believe it was a white truck, and they took him away. Those are the parameters of what I understand the incident in general terms. And I believe the arrest occurred just about 11:30 in the morning on June 20th, 2019. From my perspective, that was the first incident of that type of arrest that occurred here in Thurston County in the courthouse. To my knowledge, I researched in the past, and no arrest, I believe, have occurred here in Thurston County courthouse of ICE agents coming in and arrest an individual. So that's really in terms of the background of the situation, and perhaps some of the stakeholders in around the table may have a different additional information, perhaps, or maybe correcting me on some of my knowledge of the incident again. So that's what I have for you.
And I would ask if anybody's going to start again. I would ask you if you're going to speak, and you're welcome to, of course. Just identify yourself by way of a reminder as to who you are and what you do. Thank you.
So, and I do ask you to pass the microphone, since we don't have that many microphones available to us.
So who would like to go next about the sequence of events? Kind of keep it sequential if we can. Judge Buckley, go ahead, sir.
Thank you, and I've arranged to go first because mental health court started 10 minutes ago.
Oh, that's right, yeah.
And I need to get there, but this was important enough for me to be here to share information with the commissioners and with the rest of our community. Further context from my situation is I was on the bench that morning conducting court proceedings, and it was sometime over the noon hour when I was approached by our probation manager, who asked me if I was aware of what had happened, and I said no, I was not. I had no idea. And he described the situation, which I believe you have a copy of his notes from, of the arrest as detailed by Ramiro. And I asked him to go back to his office and put it in writing, because it seemed significant enough to me that the details were going to be important, and I wanted him to put it in writing while it was still fresh in his mind. And later that afternoon, he sent me an email with that description that was in the article that was posted in the Olympian, and the one that's available here today. I have three thoughts that I wanted to share before I have to go back to court. The first is, philosophically, as we look at this as judges and then just as community members, Chief Justice Mary Fairhurst had sent a letter early in the year to the administration of Homeland Security, asking them to respect the integrity of the court properties, and with a concern being that actions on court properties would have a chilling impact on people who use those properties. And I share that concern, and I want to make it clear that when we say that, it doesn't just apply to people who are summoned to court because they happen to be defendants in a criminal action. It applies also to people who are coming to court affirmatively to seek protection from the court. And for example, in domestic violence protection orders, people who want to petition the court to get a protection order. It also may be somebody who is a plaintiff in a civil action. We frequently have non-English speakers who are filing lawsuits and need to have access to the courts. I'm concerned about the impact on those folks. I'm concerned about the impact in criminal cases not only for defendants, and if they don't appear, then they get a warrant for their arrest. And the last thing we need to do is have an inordinate number of warrants being issued. And then there are people who are witnesses in criminal cases who may decide not to show up because of some concern that they have. And we do a lot of weddings here after we conclude the day. And a lot of those weddings are among people who don't necessarily speak English. So it's a whole host of people who can potentially be impacted if they are afraid to come to the courthouse complex. So I share that concern that the Chief Justice had expressed in her letter to Homeland Security. The specific concerns that I have as a result of this incident are two. One, the fact that I did not have a clue what was going on until one of my employees came up to me over the lunch hour and asked me, was I aware? And I had to say, no, I had not a clue. That concerns me because as a presiding judge, people are going to ask me questions, whether they are staff members in district court or they are participants in some of the court proceedings or they're members of the public who are coming into the courthouse. They're going to expect me to have some information to be able to answer their questions, and I had no information at the time the first question was asked of me. I would really think that notice to the county and notice to the officials that should get notice would be entirely appropriate. And so that's a big concern I have. The second concern I have is partly related to my function as a judge and also partly related to my function as a member of the community. The optics of this are horrible. So as it was described to me, when you have three people who are not identified at the moment they are engaging in this action in a public space, who are taking one other person down who's not identified in any way, they are then handcuffing this person and taking this person and putting this person into an unidentified vehicle. I mean, it has all the lookings of a kidnapping. Mm-hmm. And yes, my probation officer, who has Department of Corrections experience, happened to notice a badge on the belt of one person and firearms on the belts of two, but never did see, from his public viewpoint, any identification as to who these people were. He was able to make some assumptions and concluded that it was likely what exactly transpired. But my concern is somebody pulling up into the parking lot out here, walking in to come to the courthouse for whatever reason that day, seeing three people take another person down and take that person and put him in a truck all unmarked. What are they thinking? And I don't have an answer for them at that point in time. And it sounds like it happens someplace else, not in Thurston County, not in the United States. And that's a concern I have. And I appreciate the time, and I have to get back to work.
Thank you for taking the time, Judge. Appreciate that.
So,
Judge?
I'm Christine Schaller, presiding judge of Superior Court. Although I don't agree with all of the facts as were laid out by the county manager, I don't think that it's helpful to micromanage the details of the event. We're here to talk about kind of steps forward and how to handle situations in the future. I'm going to echo what Judge Buckley said, and from Superior Court's perception, one of the most important things is that people have access to the courts. And as Judge Buckley indicated, and we completely agree with, it's not just someone who is charged with a crime, and certainly someone charged with a crime should have access to come to their court dates, but we have many other people who come to the courts, who need to come to the court to seek protection in domestic violence cases, people who are so victims or alleged victims, witnesses for trials, parents who have children in dependency cases who might be afraid to come to the courthouse for fear of what will happen and can lose custody of their children and perhaps their parental rights because they cannot participate in their proceedings. That as we move forward from this incident and look at appropriate ways to handle these situations in the future, if they were to happen again, it has to, from the court's perspective, center around access and openness to the courts. What we discovered, certainly after the fact, is that we did not have in place a good, well, we did not have a policy about how to handle a situation related to this for our staff. And since this incident, we have, Superior Court convened a group which included District Court. It included our Superior Court Administrator, the District Court Administrator, the Deputy District Court Administrator, the Chief of our Security, a representative from the Sheriff's Office, 2 judges, Judge Skinder and Judge Lanise, our Operations Manager, and Grace O'Connor from the Prosecuting Attorney's Office to look at drafting a policy and protocol that could be followed in situations like this that is easy to follow in a situation that can be obviously highly charged and that people don't necessarily anticipate something like this is going to happen. And I would say that what we have, a draft has come out of that committee. It is going to District Court for their review and approval, and it's going to the Board of Judges next Thursday when we meet for our review and hopefully approval. This is an interim step because the state has passed a law that requires the Attorney General to draft a policy for all courts throughout the state of Washington. They have a year to have that in place, and ultimately the courts are required to adopt that or explain why they are not going to adopt that, and that is going to be a comprehensive policy. What we have been told through this process of our meeting and convening people to come up with a policy in the interim is that the Attorney General's office has hired someone to do that for them, and that is Nick Brown, who previously was counsel to the governor, to undertake what is a pretty sizable piece of work. And once those are completed and distributed, the court will be looking at those. And again, if we don't adopt what the state drafts, we have to explain why we will not adopt the model policy in this on this issue. We take the issue very seriously. We are concerned because we don't think that the situation happened the way that it necessarily should have happened, and that we didn't have a policy in place instructing our staff on how to handle the situation. We didn't. We do now, and we have the draft, and we'll be looking at adopting that. And so in that regard, we should have had something in place, and we didn't. But we are remedying that moving forward so that there is a clear path forward for the court and for our staff, who are really the ones who would be dealing with this situation in the moment. As Judge Buckley indicated, it was a substantial amount of time before everyone became aware, and when I say everyone became aware, in our Superior Court, what had happened. I was not here that week, and so I wouldn't have known. But even other judges within our court and our court administrator did not know in the moment. So we also are looking at the communication piece if something like this were to happen again. Anything you'd like to add?
Judge, I have a couple questions if you don't mind.
Yes.
So the Attorney General has a year, that's up to June 2020, to come up with an interpretation or policy?
Correct. Policy.
Policy. And that would just be a policy. It's not a law or an opinion. It's an opinion on policy or policy, but not a legal opinion, right? It's just a policy.
It would not be a legal opinion. That's correct. It's a policy it's a model policy that courts could adopt on how to handle situations such as this when potentially someone from the federal government comes to your courthouse and how you would handle that situation.
Okay. And the policy group that you're speaking of that has a draft policy now, that would come before the review committee in the courthouse, and the court would adopt that as a court policy?
That is correct. So that we have something in place now. I mean, heavens forbid this happens again, but it definitely could. We want to have something in place so that everyone in Superior Court understands how we should be reacting to these situations. There's no confusion. When the model policy comes out, we are required to adopt that, and it's going to be comprehensive. What we have is much smaller than what the model policy will be that's going to come out of what the Attorney General's office is creating. And we will be required. I cannot imagine it's going to be contrary to what we adopt in the interim. It will just simply be much more extensive.
I would think so. But that would be court personnel, not for the sheriff's office, but for the court. Unless the sheriff's operating inside the court. I have to understand that differentiation.
So this is a policy that the courts would adopt about how it would handle and like how our security would handle and interact with other agencies and other departments if this situation were to happen. And the sheriff's department was part of the group that met when discussing this and coming up with the
Okay.
draft.
And for clarification, the court security officers work for the court.
That is correct.
Okay. And one final question, that is, when the policy comes out of the AG's office, are we allowed to be more restrictive or less restrictive, or one or the other, or we can't be less restrictive, we have to be as or more restrictive? How does that work?
I don't expect it to be a restrictive policy, but I mean, I think it'll be broad when I say that. If we do not adopt that policy, we have to explain, like let's say we don't adopt page 23. We would have to explain in writing why we were not adopting that portion of the model policy.
Explain that to the AG.
That's correct.
Okay. All right. Any questions? Any questions?
Judge Buckley touched on notice, and so is that kind of where your policy's directed, or is it broader than that? I mean, it sounds like you're not going into detail, but can you give us a sense of the scope of what you're addressing?
And I've been somewhat not specific because it has not come in front of the Board of Judges yet. Only Judge Skinder and Judge Lanise worked on it, and they finalized the draft yesterday.
Okay, so it's hard.
But this is how our staff and how security will handle a situation if someone were to come into the courthouse again with a gun, identifying themselves in such a fashion, really any law enforcement agency, so that all law enforcement agencies are treated equally when they come into our courthouse.
Questions, comments?
And it does address notice in there, but that's not the majority of the policy.
Do you have more?
I'll let that go.
Okay. Thank you, Judge.
Thank you.
Looking, searching, looking.
Public defense.
Pardon?
Public defense is next.
Oh, there we go.
Sure. Well, just to follow up a little bit more on the details, again, Patrick O'Connor with Thurston County Public Defense. And to my right is Larry Jefferson, who was present during the incident that is essentially the precipice for us meeting here today. So I'll let him talk a little bit more about the details, and then I'll speak a little bit about some things that we've been doing as after action items.
Can everybody in the audience hear? No. Okay. Make sure it's on and speak up if you don't mind. Thank you.
Good afternoon. My name's Larry Jefferson. I'm with Public Defense, and I was present on that particular day. One thing that was very concerning is that we were first informed of this from a corrections officer who let attorneys who were in court know what was going on. Thank you so much. And so at that point, we had no idea who the individual was, and we did not know until the next day that it had been one of our clients. our normal protocol with anyone who has any potential issues is to be in contact with the Washington Defender Association. So those processes had been in effect at that time. But also, once this incident occurred, we know that we're supposed to get into contact with them so that we can notify them. Because incidents like this have been happening across the state, and in order for any coordinated response to be done on a statewide basis, WDA needs to know where these incidents are occurring. So on that day, we did get in contact with them that there had been an incident. We weren't able to tell them specifically that it was our client that was involved in this incident. But needless to say that as it went through the courtrooms, that there had been this incident just outside the courthouse with an unmarked van with people who had not been identified. We had no idea who these individuals were. We had no idea that individuals had actually entered into the courthouse. These individuals did not, to my knowledge, contact the defense attorney who was involved, and we had no idea sort of, what was going on. So we sort of got this information, and then people started contacting either myself, WDA, or other officials so that word could get out. And I would agree that there was no specific protocol established for us to say to contact, who will we contact at Superior Court, or who will we contact at District Court. And so I look forward to seeing whatever policies that are drafted so that I can inform my staff who they would contact once this issue, if it ever happens again. I know that I'm personally involved with some community groups to address this issue. And this is something that's very important to us because we want to make sure that our clients have access to the courts. Also, unfortunately, this individual in question was not able to appear for later court dates, and so wound up getting a bench warrant for their arrest, which for me would seem to be unjust because this person had appeared for court and likely would have shown up for court again. What I'm afraid of is for any future clients to be afraid to come to court. It's already nerve-wracking enough to have a court experience. If you're not a lawyer or if you're not a judge or a court official, people are often nervous. And to not know whether you're going to go home or not, and that your attorney cannot tell you what's going to happen is extremely nerve-wracking. And so our courts need to be a safe place for our clients to come, their families to come, not only to deal with their court issues, but to deal with any issue that would happen here at the court complex.
Excuse me, before you go on, Larry, Judge, I missed all of the names in that policy development group. Was the public defense included in that drafting of a policy?
No.
Okay.
So, this issue was unfortunate, obviously, but it really came as no surprise to us at the Public Defender's Office. We've internally been bracing for an incident like this. As stated earlier, these incidents, unfortunately, have been happening all over the state of Washington. And in our public defense community, there's been a lot of communications on how we're going to go about dealing with this situation should it arise in our county. And it has, and I applaud and appreciate this meeting being held. This is an opportunity. As Larry mentioned, we've, some part of our after action steps have been to start to work with our community. That's largely represented here today. So going forward, we will continue to hear from our community because I certainly think it's important as we set policies and start to address these issues that we hear from the community that's directly affected by these actions. As Larry mentioned, this, and as I think Judge Howard mentioned as well, we see this as an access to justice issue for everyone that comes to the courthouse, whether it's our clients or witnesses or victims in cases, whoever that may be. It's access to justice for everyone in our community. As stated earlier, and there may be some discrepancies or disputes on how things went down, but I think it's undisputed that it went down in a manner in which none of us would want a situation like this to go down. Larry and I have been public defenders here for a long time. We've had a lot of our clients arrested in these courthouses by local law enforcement, and their process is vastly different than that took place. It's very professional, it's very safe, and it's collegial, the way it should be done. And our fears are that this could continue to happen. It could continue to happen to individuals in a dangerous manner in our courthouse courtyard. And frankly, the way this issue was resolved was a risk. We have been meeting with, as I said, various community groups, and additionally to that, we've just left the meeting before this meeting with a representative from the Washington Defender Association who's here today, Ann Benson, who's right here, who's frankly an expert on these issues in the state of Washington. And so as any case that I represent or Larry represents, when we don't know the answers, we ask an expert. And Ann has been kind enough to take an hour before this meeting to meet with us and the prosecuting attorney, Elizabeth Petrich, to sort of get a statewide perspective on these issues. And in regards to courthouse policies and procedures, yesterday was the final draft that was issued by a large group of organizations in the state of Washington that's made a proposal on proposed protocols concerning civil arrests around courthouse, and I'd be happy to share that with you, Your Honor. Well, we've made copies here today. I'm happy to distribute those as well as some information from the Washington Immigrant Solidarity Network. So it gives some perspective on what other counties are doing around the state in response to these issues. Again, I really appreciate you guys calling this meeting. It's a very important topic, not just for us as Thurston County employees, stakeholders, policymakers, but for this community. And hopefully as we have maybe more meetings on this issue, that there'll be additional opportunities in addition to addressing the board in a public meeting where we can start to get some feedback from these community groups.
Thank you, Patrick.
You bet.
Very much. And I would love to see eventually a copy of that.
Sure. Yeah,
What you have.
Ms. Benson was kind enough to bring.
What's the title of that, Larry, at the very top?
This is the proposed protocols concerning civil
Oh, I
arrests.
don't have that. Okay, good.
Yeah, I'll hand it out.
You have something else? Yes, Judge, I'm sorry.
I wanted to follow up on your question. You asked whether or not public defense was involved in our meetings. What our meeting was a court policy, and so the representatives were from district court and from superior court. When I indicated that Grace O'Connor from the prosecuting attorney's office came, she represents the court, and so she was there in that capacity, not as a representative voice of the prosecuting attorney's office. We would never hold a meeting and invite the prosecutor and not invite defense. I could tell after I answered the question that perhaps there was some confusion around that issue, and I just wanted to clarify
There was
that.
follow-up questions. I'll scratch that. Thank you, Your Honor. Thank you very much. Now returning to the prosecuting attorney's office. John Thunheim.
Well, let me start out by really echoing a lot of the concerns that we've already heard. I think it's pretty clear that the criminal justice stakeholders that are here today are here because we are unified in our concerns about what happened and what the future looks like and what our response can be to this. I don't have anything to add or clarify any of the factual accounts that have happened here. Our information came actually much the same as the public defender's office And as a matter of fact, I think our source for this was the Public Defender's Office, who, because we have a good line of communication between our offices and our lawyers, were sharing information back and forth about what had happened in this particular incident. And I was, at one point, hopeful that the letter that was issued by Chief Justice Fairhurst had been considered, I guess, for lack of a better word, by ICE, and that they had decided to refrain from conducting any of their enforcement activity around the courthouse. And up until this incident, it appeared that perhaps that the letter was being heeded. Obviously, this changed the landscape. And one thing that concerns me, in addition to what's been said, is that at least I personally, and I can't speak for any of the other stakeholders, haven't really heard anything in any kind of official capacity from ICE representatives about whether there's an ongoing intent to do this kind of enforcement, if this was a one-time aberration, if there was something unique about this. Again, me just speaking personally, from the information I have for myself and my deputies, we haven't received any kind of communication from anybody at ICE about what the intention is going forward. So I think our reaction is to respond in the ways that we have control to respond to, and to try to prepare ourselves for whatever might occur in that regard. I also wanted to make a general comment about the concerns that we have in terms of interference with the court process, and we each have our own respective mission and concerns when it comes to criminal justice. I think that's obvious to everybody. The court obviously has a duty and a mission to be the neutral arbiter of disputes, and to create a court environment that is safe for everyone to be heard and for everything to be considered in that mission to pursue justice, if you will. Public defense, obvious mission there to protect the rights of their clients and to ensure due process. Our mission, similarly, is to pursue justice on behalf of the community. And I want to make sure everybody understands that when something like this happens, that interferes, from my perspective, with that mission in a variety of different ways, which have been alluded to, but I want to be very specific about how that applies to our mission. One is, when we are in an active prosecution against somebody who is accused of a crime, we have made that allegation on behalf of the community and are seeking justice on behalf of the community, and accessing our local justice system to do that. And so when something like this happens, in my view, it's actually the federal government usurping itself into and interfering with a local government's ability to conduct its justice system, regardless on in what role we're in or what side of the table we sit on. It's flat interfering with the system itself. And from our perspective, as has really happened in this case, from my understanding, is it basically stops everything. So we can't act, defense can't act, court can't act, nothing is happening on this. Now, selfishly, from a tactical standpoint as a prosecutor, time is always a prosecutor's enemy, right? We generally are seeking to try to resolve our cases in as speedy a measure as we can reasonably do so, because evidence fades and dissipates over time. Now, that's just a pure tactical statement, but what happens when something like this occurs is, when it stops the case, who knows when we might be able to actively take up again this case. And I think realistically we might say that both sides, as evidence erodes, it gets much difficult for both sides to really do the job we're intending to do, and that is to seek justice and have a fair outcome to whatever this dispute is. So that is a major concern for us. And along with that, of course, is the obvious one from the prosecutor's standpoint, and that is that now any witness that we're working with, any victim that we're working with, whether documented or not, who has any concern about coming to the courthouse because of the possibility of some kind of federal activity, ICE activity, now is inhibiting our ability to move forward with our case. And as already been pointed out, there's a cohort of victims that are working with us in active prosecution cases that are also seeking civil redress in terms of protection orders or civil claims or whatever that might look like. And that also is being interfered with as well. So that's why I say we are unified in our concerns, even though we come at it from a different perspective. And so I will say that at this point, we are now committed to provide, and I should have reintroduced Elizabeth Petrich, who is the chief deputy in my civil division, who has spent a lot of time over the last few weeks now studying this case, these issues, the Keep Washington Working Act, and we are committed to providing the ongoing legal support that we are obligated to provide to all of the county agencies that are affected by this, the courts, the sheriff's office, any other agency that has policy implications, and are very much committed to working collaboratively with our justice partners and the board and everybody else, the community for that matter, to try to minimize the risks and the concerns that have been created by this activity. So I think I've gone on long enough, and thank you for the opportunity to speak.
Thank you, John. Now we have some from the Sheriff's Office. I'm turning to County Manager Ramiro Chavez again.
Are we going to have some questions?
Sure, certainly, yeah. Do you have a question now? Go ahead.
Yes.
Yeah, go ahead.
What type of a case was this? I mean, I know it was some kind of a criminal activity, but was it a high profile? Were there witnesses to be called, or was he going to be a witness against somebody or anything like that?
I would not consider it a high-profile case.
Okay.
It was for the most part, a routine case, to the extent our cases can be called routine. It was impaired driving, attempt to elude, I think were the charges involved in the case. There was nothing particularly different or unusual about this case or this defendant.
Not a lot of publicity on it or anything.
Not that I'm aware of. Not that I'm aware of.
No, but Commissioner, I think
You wanna save it for
it's a really poignant
discussion?
question, and a question in which, we all at least have considered, is that it wasn't necessarily a high-profile case or a media case, and without, with a lack of understanding on the criteria in which agents are reviewing cases to determine whether or not they're going to take action with an administrative warrant or a judicial warrant. We have to sort of, from this point forward, operate under the guise that, it doesn't need to be a high-profile case based on this case. So it's a really good question.
I guess one of the issues that I was concerned about was the fact that there is always a possibility, I guess, that obviously, this was a pre-planned event. So somebody tipped ICE off prior to this happening. It just, they just didn't happen to be hanging around the parking lot. Somebody had to tip them off. And that's why I asked if it was a high-profile incident or not, or maybe if he was going to be a witness or not. But you could see, having the experience of doing this, we're going to hear about what the sheriff has to say in a minute. I'm not speaking for the sheriff, but having been there in years past, I can tell you that the officers that are actually the security arm of the courts, they, as a general rule, have no idea what's going on and which cases are being heard. So something well ahead of time tipped off the ICE folks. And it certainly wouldn't be an officer because they wouldn't know. They'd have no knowledge about any of this going on. So I was just wondering if it was high profile enough that maybe somebody that was going to be either a potential defendant or maybe somebody didn't want to have something said in court. But obviously this had to be pre-planned, and I think that's where we have to focus our energy on coming up to a solution on this particular issue is recognizing that that's the more probable area of concern rather than those individual officers, because they just don't know the cases that are going on around them. They're just there to supply the security to the court.
Just wanted to add that along with the absence of any information coming from ICE about future intent, there's also been a kind of a lack of any kind of information about this case at all, or what was it about this case that caught their attention, or whatever it was. So it's really kind of difficult operating in the dark around this in that regard. I also wanted just to make a quick comment to follow up. I intended to do this originally in I think Patrick's comments about there have been arrests conducted at the courthouse by local law enforcement over the years on several incidents. That happens. It is part of being a part of the justice system. But I echo everything that he said in the sense that we've never had an incident in my memory, and I've been doing this for almost 30 years now, in my memory, that was kind of, that happened in quite this way. And in a way that there was a complete lack of information or communication to anybody in the courthouse about what was going to happen, what was happening, what was going to happen, or what could happen from tactically. So thus my understanding as a corrections deputy is out there, has no clue what, so from a tactical standpoint, this would be, from my experience, really unusual for law enforcement to do something like this without communicating with other, partner agencies, so that everybody has an awareness. But I think that's exactly what happened. I don't think there was any communication about this whatsoever, as far as I know, and I've not heard of or detected any evidence to the contrary. And so that is, I think, I'm not an expert on law enforcement tactics, but I've worked with law enforcement a long time, and I've just never seen anything like this.
Well, I have to say it's a safety issue. It's a big safety issue.
Well, that's a question I have, but I'm going to wait until I hear the sheriff's statement. It may be answered. Yes, Judge?
I just wanted to indicate, with Commissioner Edwards raising an issue as to whether or not someone was tipped off. In these cases, we have no idea what a person's status is in the country. We never inquire, ever, what a person's status is when they come before the court. That's nothing that's contained in any of the public files. And so that is not like a piece of information that the court has. I don't know. I can't imagine that's a piece of information that the prosecutor has unless it was somehow in a police report. And if defense has that knowledge, they're not disclosing that to anyone, but are advising their clients accordingly. So how anyone knew about this hearing, we really don't know, because that's not in a public file that someone could look up in any circumstance and say, hey, this person's coming to our courthouse on this day, and maybe they're not here in the country legally. And so I'm not saying that what you're saying isn't true, but it doesn't seem like that could have come from us, because we simply don't have that information, nor do we seek it out, nor do we want to seek it out for the reasons that we have been talking about.
Well, I'm not alleging anybody. I'm just saying there's the possibility that there could be something. I certainly did not intend that the court be scrutinized about this at all. I'm concerned from a safety standpoint.
Absolutely.
If those officers had been in some type of a windbreaker with police on the back or something, maybe their vehicle is marked, I don't know, some way to protect an overzealous citizen from intervening or something like that, or an officer that has nothing to do with it, maybe an off-duty officer. We could have a real bad situation develop here if we don't get a handle on this.
Agreed.
County Manager, please.
Obviously, the Sheriff's Office is not present in this meeting, and so I received a message from the Sheriff's Office stating the Sheriff's Office representative is unable to attend this meeting, and it was attached to the email a copy of the memo written by Deputy Jones regarding his involvement on this arrest. This memo, written by Corrections Deputy Corey Jones to Chief Toma, hasn't been made available to the public, and I have copies available to you. Can you
I hear you.
Is that better? No? Yeah? They cannot hear me. So this is the memo written by Deputy Corey Jones to Chief Toma. And that was written back on the same day, on June 20th, 2019. And again, I have copies available to you. If you'd like to take a copy, there's two elements that I want to highlight on this. According to Deputy Corey Jones, he was responding to a radio call by a security officer related to the actions that were going on while this individual was being arrested by the ICE agents. Also in this memo, Corrections Deputy Corey Jones made a statement to Chief Toma that he had engaged with Captain Eden, I believe his supervisor, where Captain Eden asked him if he was aware of the presence of the ICE agents. He stated no. That would be Corrections Deputy Corey Jones. And also if he has informed ICE of any presence of this individual who was arrested, and the answer was no. There's a little more detail on that memo. Those are the two key elements of that memo that I'd like to share with you today. And again, copies are back here.
Going back to what you just read, and especially going back to what has been echoed, that it's a safety issue, officer safety type issue. And I'm not going to put Deputy Chief Aaron Jelsic on the spot here, but I think he may agree when I ask, how many cops does it take to keep a secret? And the answer is none, because they can't keep a secret. So if this was a high-profile case, if this was a dangerous person out there, I know darn well Thurston County Sheriff had been notified. They would have been on the perimeter. Things would have been set up differently than what had transpired. So my question was going to be, was the Thurston County Sheriff notified? And my guess is no. But again, that's nothing but a guess. So it's kind of disturbing that that didn't happen. But again, I don't write ICE protocols or policy either. But that kind of answered my question. Yes, sir?
I do want to make that answer. I actually asked the sheriff at some point here since this incident. He had no knowledge of it, but that's what he told me.
So now we're going to open this up. If anybody else at the table would like to add any comment or ask anybody else some questions to fill in the gap, then I'm going to open it up to the table. This table's first. Anybody?
Okay.
I'll just make one final point on that issue.
Thank you, Patrick.
Well, I think I'll shut up. So I think just circling back to the issue on if anyone was notified and put on notice. And I don't know all the details. I haven't spoken to everyone, but we don't have any reason to believe that anybody was tipped off. But I think it's important to note that, court calendars are essentially public records, and anybody can access a court calendar. And that, I think, is part of the discussion going forward on we have to operate under the assumption that, these officers in the future can be continuing to look at public calendars, scheduled court date, mandatory court appearances, in this case for a criminal case, but it applies to every other case, and operate on the assumption that without any coordination, they can be present at any of those court hearings to execute a warrant. So I think that's the reasonable inference and the more likely scenario we faced here and will continue to face going forward.
Do you have anything?
I have a lot, but
okay.
For one topic, try topic. I'm trying to respect the agenda.
Okay, well, I'll go to
I don't have anything about that.
Then we'll open it up.
Just for, I don't know how many people read this. It's obviously a very important topic to our community, and I want to compliment the Olympian on that very extensive article that they wrote about this particular issue, because it does have most all the facts that we were aware of were in that article. So if you haven't had a chance to read that, it gives you a pretty good breakdown of what took place on this. And I don't always recognize accuracy, always.
Yeah. Well, now we're in the part of the agenda that's open discussion, and again, that's for folks at the table. And go ahead and let her rip.
I'll go. So the concerns, my concerns are much broader than just, and somebody might show up, drive up, and intervene and create a safety problem. My concerns go to the things expressed by Judge Buckley and Judge Schaller and John Thunheim and Mary Fairhurst in her letter about the administration of justice. And my concerns even go beyond that, but I think that's enough to understand from my perspective that we should be doing what we need to do as a community to protect our justice system and the folks that are accessing it. The discussion at the tail end there was about, well, why is ICE doing this? Why won't they listen to Mary Fairhurst's letter and stuff? I mean, there's an argument that it's illegal, these arrests. And that argument was pressed into a federal court in Massachusetts, and the judge, and I'm not aware of an update to that, but I've got the opinion, and they said based on a well-established common law privilege against civil arrests at courthouses, ICE policy does not supersede that, and therefore these arrests are not legal, and they enjoined those arrests. So I asked Elizabeth and earlier in the summer, how could that apply here? Is there any reason why it wouldn't apply here? Should we be doing that? Who would do that? Is it the prosecutor's office? Is it Bob Ferguson? Is it the county commissioners? I don't know who's the parties. I think in Massachusetts it was a couple of neighboring counties' prosecutor's office and a nonprofit group. But the standing analysis in there, I think, is broad enough to give some number of stakeholders in our community absolute standing to make that argument. And I don't know if there's any reason not to make that argument. That would solve this problem, because we would be able to say that you can't come here and do that, or a federal court would be able to say that. So I would like to talk about whether or not that's the right course of action. If it's not, then I think we should be evaluating the policy proposals that could potentially help mitigate. I was handed I was handed a packet by Strengthening Sanctuary, a group that works on these issues here locally. They've got attorneys, they've got people that work really hard. I've known about this group for a while, they do good work. There's interesting proposals there. Just handed what everybody else was handed from the Washington Defender Association and this whole, it's actually a whole bunch of groups that Patrick just mentioned. I haven't seen it yet, but I know these are good groups. I'm sure they worked hard on these things, and we should be going through these step by step to figure out what is going to apply to Thurston County that is going to be appropriate. Maybe not everything, but I already saw things in the Strengthening Sanctuary list that I think would be appropriate. So I'm hoping that we'll do that at a minimum. We'll discuss maybe a more aggressive approach in court. And then segueing to the last step on the I think connected to this is the Keep Washington Working Act, and whether or not, there's sections in there. Section 6 applies to law enforcement. Again, this is segueing into another topic, but the arguments that I had heard previously about how Thurston County Sheriff's Office conducted its information gathering policy are directly addressed by Section 6 of that act. So I think that requires a reevaluation of how we're doing things there, and that's something I've asked for legal guidance on as well. So I've kind of been waiting for the door, there's a lot of legal questions here, and I kind of need to know what the doors are before I can sort of propose what door I think. I'm just one commissioner, but what doors I think we should be walking through. But I think there's going to be a lot of doors that we should be evaluating.
So you brought up the Keep Washington Working Act, and Romero's going to talk about that at the end.
Okay.
But you mentioned Massachusetts court case, and that's important to discuss.
This is more as an informational, which is relevant to the whole conversation today. And I have made copies available back there, and this is the copy of the article by the Boston Globe, which is published on June 20th, 2019. And I'm just going to read a paragraph. I'm not going to read the whole article. and goes along with what Commissioner Mensah stated. And this paragraph states the U.S. District Court, U.S. District Judge, Indra Tolwini, granted a preliminary injunction to, that stops U.S. Immigration and Customs Enforcement from civilly arresting parties, witnesses, and any others attending Massachusetts courthouses on official businesses while they are going to, attending, or leaving the courthouses. So, and again, there is a lot of information related to this particular article. You're more than welcome to get a copy. And certainly you can search that online as well. Again, it's from the Boston Globe. The reporter was Denny McDonald, and the article was issued again on June 20, 2019. No much getting into the discussion, but I think it's related information to what we're discussing today.
Do you have anything to add on this case?
I'll just make a couple of comments about it. So I want to say that we are very aware of the Massachusetts case, and we've actually been spending a fair amount of time since it came out and since it came to our attention, studying the case, looking at how the arguments were framed and so forth. As the lawyers at the table know, there's nothing specifically binding by that case on our court if we pursued our own lawsuit. So the implications of that is, if we were to pursue our own lawsuit, and I'm going to say without going into detail, that I think that is a consideration. Frankly, I'll say I am considering it. And that's why we have been studying this so closely. But for various reasons, I don't want to go into the weeds of that too much. But that being said, that court case isn't binding, so we can't just walk into a Ninth Circuit, Western District of Washington court and say, hey, Massachusetts did it, why don't you? We've got to be prepared to go in and to make our own case. And that's essentially where we're at, is looking at the arguments that were made, comparing that to what evidence we might be able to bring, and whether we can frame similar arguments. I do think, just my general experiences with the Ninth Circuit, that they would consider that Massachusetts opinion in a pretty persuasive way. That's just my kind of initial reaction after having read the opinion. And I frankly agree with the policy that's in that opinion, that there should be, if there's not already recognized, a common law right to access local courts by all parties, which is what we've been talking about. So again, without drilling any further, that is on the table, and we're talking about it.
I don't want to put you on the spot, Judge, but did you want to say anything about the Massachusetts case?
No.
Okay.
I don't have anything to add, and that's not something that the court, it would not be appropriate for the court.
Okay,
to
I didn't
be
think so, but I just don't want to leave you out.
involved, and that's a federal issue. It's not something that the state courts would be hearing, and that's why I don't have a comment
Okay.
on it outside of what John has been talking about.
Okay.
So related to that, Commissioners, I will be scheduling an executive session where John is going to be coming, and as well as Elizabeth, to have a conversation with you and can further explain some of the options that John alluded to. That is coming up.
All right. It's interesting that that ICE, ironically enough, ICE has had a chilling effect on this community. By virtue of this room being packed and overflowing, and generally that doesn't happen unless it's National Cupcake Day and we're giving samples out at a BoCC meeting. So I'm very happy and thrilled that so many of you folks came out. But I'm going to turn to the next steps now. To Romero, the next steps.
Yes, and I'm going to just introduce the subject for the either Elizabeth or John to further elaborate on what that really means, the Keep Washington Working Act. That's the new law the governor passed this year. I believe it came into effect in May or June of this year. I'm not sure. So I know the prosecutor's office has been working on this new law and see how the county can do something in order to be aligned to the new law.
So,
Bring it right as close as you can, Elizabeth, into the microphone. Or hold it. There you go.
So, yes, the legislation at issue is called Keep Washington Working, which
Can you all hear? You got to get that mic
Oh.
right to you. There you go. Thanks, Elizabeth.
the legislation is called Keep Washington Working. And when I first started hearing about this legislation, I thought it had to do with ICE immigration, so it was kind of, it didn't make sense to me why they were calling that, but it actually does make sense. The fundamental background or purpose of the legislation was to recognize the value of what the immigrant population brings to the state of Washington in terms of commerce and economic development. And and to keep immigrants working in Washington. So that's what started, that's a big, or the first part of the legislation, is that we want to treat all of our residents the same. We don't want to discriminate them in any way, and we want to protect all of them the same way. So that's the Keep Washington Working piece of it. But the other big purpose of the overarching purposes of this legislation is to minimize immigration enforcement in the state of Washington and to minimize the deportation of immigrant people from the state of Washington. So to implement that, the legislation has certain mandates in there specific to courthouses, schools, law enforcement, shelters, and healthcare facilities, because these are the areas that the immigrant population can be targeted in. So the legislation directs mandates that specific state agencies review their confidentiality policies in order to make sure that agencies are not using that data for immigration purposes. It prohibits state agencies from using their resources to investigate, enforce, or assist with immigration enforcement policies. It clarifies that local police officers do not have the primary purpose of enforcing federal immigration law.
I think people are having a hard time hearing you.
Oh, okay.
Also, yeah, especially when you start to turn this way and don't bring the mic with you.
Okay. So one of the pieces of the legislation clarifies that it is not local law enforcement's duty to enforce immigration law. It also prohibits local jails from being used as holding cells for immigrants. In the past, there have been agreements with local law enforcement and ICE to hold immigrant detainees. That's actually being prohibited now. It prohibits state agencies from asking about immigration status from people or to provide information to government except where it is in relation to a criminal investigation. There's a big distinction in this legislation with respect to immigration issues and enforcement. It is clearly protecting immigration issues on the civil side. It still allows law enforcement to proceed as it does in criminal investigations and things like that. So it's really, which I think is important because it's also, it's not impeding the work of law enforcement, but it's also protecting the people that are getting swept up in law enforcement, immigration issues. it prohibits local law enforcement agencies from giving federal immigration enforcement agencies access to interview people in their facilities, in their jails, in their cells, which is actually what prompted ICE in their recent directive for courthouse arrest, which the most recent ICE directive was in 2018. And they say the reason we need to go to the courthouse is because local law enforcement isn't cooperating with us anymore. And that actually started back in 2014 with a different case that said that local law enforcement could not detain an immigrant longer if that person was in jail for a criminal violation and their time was up, they needed to be released that day. Local law enforcement did not have the authority to hold on to them. So that was a law that started in 2014. So that's when things started shifting with local law enforcement in terms of 100% cooperation with ICE. So this law is just strengthening that and making it clear for local law enforcement that you cannot detain people. That was originally, that came out in case law, but this is now a state statute. So the law, it forbids local law enforcement from detaining people or transferring people on behalf of ICE. It prohibits local law enforcement from being deputized by ICE officials. Previously, ICE could deputize the local law enforcement officials to carry out immigration enforcement, but that is no longer available in Washington State. And it also directs the Attorney General's office to develop model policies, which you've heard Judge Schaller speak to. Those model policies likely will not be available for several months. In the meantime, this law still is effective immediately, which is why it's important and which is why everyone around the table is concerned about trying to get interim policies in place until we have model policies. And the policies specifically need to address courthouse issues and law enforcement issues, as well as looking at how the county collects information, if we do collect information on immigration status, particularly in relation to our healthcare facilities and any shelters that we may be operating or contracting for. So that's the very big picture perspective of the legislation.
Thank you. Commissioner?
So what drew my attention was, among other things, was the Section 6.4, local law enforcement agencies may not inquire into or collect information about an individual's immigration status. And then Section 9, when this came up like 18 months or so ago, because we had an arrest in the jail parking lot, the sheriff in Olympia adopted some policies, and I think some of the other local law enforcement agencies did as well. Sheriff did, but they were resistant to that piece that's in 4, talking about consular privileges, which is directly addressed in Section 9 of this Keep Washington Working. It says, in order to make sure that treaty obligations are respected, including consular notification, local law enforcement must explain in writing the individual's right to refuse to disclose their nationality, citizenship, or immigration status. So you just said that this law is in effect now, and I don't think we're doing that. The sheriff's office is not sitting here, but what I understood from them, it's hearsay, but I understood that they were sort of waiting on legal advice about that. The DOC is already, there are state forms for this. So I'm just concerned that we're not in compliance with this because the former argument that the sheriff was relying on has been eviscerated by this law. And this law is not waiting a year to be in effect.
Yes. So we are working together with with the sheriff's office on these issues, and they are complicated issues. There's also, I'm not going to get into the details of some of the conflicts, but very important issues that we need to continue to address as soon as we can.
You're on it. That's what I heard.
Well,
Okay.
that's what I had written down, I scratched it off also, is because you mentioned the exemption for criminal cases, and I thought good because of consular rights and obligations, but it addressed that, so it took it out. And I don't know if those stats are kept or not. When you were talking about organizations keeping stats on nationality, I don't know if the sheriff does that and discloses it. I don't know.
So, Commissioner, as to that issue, we're going to help, the public defenders are going to help remedy that. We'll continue to work with Civil Division, but we can help. There are fixes and easy fixes to some of the issues raised by Keep Washington Working that in partnership with the Public Defender's Office that we can work with the Sheriff's Office to remedy. So.
Beautiful. Anything further?
That was my main.
Yes, nothing?
piece.
Next steps, we did that. I just want to I'll make a final comment when you're done, Romero.
Yeah, and I have a follow-up items when you're ready.
Okay. Do the follow-up items now then. I think, is there anybody else want to speak or say anything? Mary Ann, you haven't spoken. I don't know if it impacts your office in pretrial services? Okay.
No, thank you.
Any other comments from people at the table? Next steps?
So what I got from my notes and some of the feedback that we received today, communication in the courthouse seems to be a common theme. That will be something that we need to explore as to how we can probably communicate among ourselves when and if a similar event happens in the future. Also, Commissioner Minster stated that we receive a document from the Strengthening Sanctuary, where they proposed several policies. That's an interesting document for a non-lawyer. Seems to be very objective proposals. And a copy of that is available to all of you back on the back table. So that is something that I will coordinate with the prosecuting attorney's office to see what elements that could be implemented, if any, and bring back to the board. Also, you receive a new document from Patrick O'Connor, which is from the Washington Defense Association, and I believe Ms. Ann Benson is present here. We also will follow up on the content of this document if there is any opportunities or perhaps policies that commissioners can entertain in the future. And lastly that I have, as I mentioned earlier, we have, I'm going to try to schedule an executive session in the next 2 weeks where the prosecutor, John Thunheim, will have a conversation with the board as to potential actions available to the county.
Thank you. Any final comments?
No, sir.
Any final comments, Commissioner?
Just my add to that list is the ongoing work to make sure we're in compliance with Washington Working Act, which we just touched on there at the end.
Ann Benson, thank you for being here from WDA. And I believe everybody, every human being deserves dignity and respect. And the fact that you folks in the audience here were very dignified and respectful gives me great relief. And it's a great reflection on our capital county. So thank you all for being here. Thank you for being respectful and attentive. And this meeting is adjourned.